Hi, my name is Franca Salatena. I am a lawyer, educator, and coach based in Perth, Western Australia. Today, I want to talk with you about the legislative requirements placed on an employer in relation to workplace behaviours, of which I'm really talking about those that fit within the unlawful space. So, sexual harassment, discrimination, bullying, victimisation, and others along a similar line. Our laws have changed a lot since 2021, and the requirements placed on an employer are now a lot greater and more expansive than they have been. So let's have a look at it. Every state and territory in Australia has a work health and safety law, and they also have regulations and codes. And globally, all of that requires that an employer do all that is reasonably practicable in a workplace in relation to 4 things. Now, I'm talking today specifically around workplace behaviours, so the way that people treat each other. But these 4 criteria can be applied to any behaviour that in the safety space in a workplace. So the first thing an employer has to do is to identify what hazards and risks are in their workplace. They then need to do some kind of assessment related to that hazard or risk. So it could be things like the frequency, the likelihood, the impact of that behaviour on people. The third requirement is that they must then demonstrate that they are doing all that is reasonably practicable to eliminate or minimise those hazards and risks in their workplace. And finally, they need to demonstrate that they have a monitoring or a review process in place. So it checks in, it sees whether the things that they have done have worked. It also identifies whether there are new risks that apply. Today, I want to specifically focus on that third requirement, to eliminate or minimize hazards. And I want to also show how that third requirement under our safety laws marries up with a requirement within our equal opportunity legislation. So every state and territory in Australia also has an Equal Opportunity Act. It might sound a little bit different. So in some states or territories, it would be called something like an Anti-Discrimination Act, but it has the same effect. And in that act, it puts a requirement on an employer, and it says that an employer is liable for all the actions of its employees unless it can show that it has taken all reasonable steps to prevent its employees from having acted unlawfully. This requirement in our equal opportunity laws is very similar to the third requirement under our safety space, to demonstrate that you've done all that is reasonably practicable to eliminate or minimize the risk. Unfortunately for employers, the legislation doesn't define what all reasonable steps look like, and you have to go to the case law and trawl through judgments to find out what the judges say all reasonable steps look like. The good news for you is that's what I've done, because I'm a lawyer and I like reading cases. And over a period of time, the courts have identified about 10 factors that fit within the space of all reasonable steps. So let's have a look at what those factors are. The first one, not surprisingly, it's a bit like the foundational building block, is that you want to make sure that you have accurate, up-to-date and useful information around what is sexual harassment, discrimination and bullying and all of the other unlawful behaviours, how your workplace will manage that situation. So you want what I call a workplace behaviours policy and procedure document, and you also want a complaint management policy and procedure document. Then the next step, or there's several steps that the courts have talked about, is about how do you let people know in your workplace that they're protected, that these kind of behaviours aren't appropriate, and what they can do about it if it's happening to them, or if they witness that behaviour happening to someone else. So the court has identified a range of things that they'd like to see you do. One of the easiest ones is notices and posters in the workplace. So in those public spaces where people hang out, do you have notices and posters that remind people, advise people, educate people about what's appropriate behaviours and how they can be protected? Then they want to see at the time or shortly after someone comes to work with you, have you communicated to them in a meaningful way what's appropriate and inappropriate behaviours? The courts are pretty clear that handing them your staff handbook and getting them to sign a piece of paper saying they've read it is not sufficient. Then we go on to other training, other communication. So what they're looking at now is all the different touch points or all the different ways that you're letting people know. So they want to see that you don't do what I call the helicopter training, which is you parachute somebody in, they deliver a workshop, and then they disappear for the next 2 or 3 years, and your staff don't hear anything else during that time. So they want to hear regular communication. So regular, maybe emails, toolbox meeting, team conversations that remind people, reflect on, talk about people and behaviours. And then, of course, you also need to demonstrate there's these moments where you're giving them some concentrated or more intense training. So that's what that regular training is. The court is also pretty clear that a one-off training doesn't constitute regular. So they want to see that you've got a history, a record that you have been educating your staff on a regular basis. And then they want to see extra training, specific training around your managers. So because a manager is in a position of authority in a workplace, they have an extra duty of care to provide a safe workplace. What that means is that if they in any way aid, assist, allow, permit, or authorize somebody to do something that's unlawful, then they're treated as if they did that themselves. That's called secondary liability. Now, the thing about secondary liability is mostly it cascades into employer or vicarious liability. So if your managers and supervisors aren't picking up on behaviours and holding people to account, that's just more evidence that's going to result in the employer being liable for the actions of that employee. And then the courts have talked about what they think best practice looks like around all reasonable steps. So within a workplace, there's 2 different types of people. One is called a contact officer and the other is a grievance officer. A contact officer is someone who is not in a position of authority. They're trained to have a confidential conversation with someone about an issue, that they are aware of the options available within their workplace and the support services. And they could also be a support person for that person if they do want to take it further. Whereas a grievance officer is someone who is trained and skilled to identify and manage a workplace issue. They could manage it informally, but they could also be the one that conducts a formal investigation. So if you are going to have contact officers and grievance officers within your workplace, make sure that they're trained on a regular basis. And that really leads into the next requirement, which is when you conduct a formal investigation, you need to make sure that it's done properly. The courts want to see that it follows what we call the principles of natural justice, so that both parties to the investigation are supported, they're giving the appropriate information, and that the process is fair and transparent. And you don't have to, but if you want to, it can be useful at times to have an independent investigator. So really just have them on your books as someone's available so that you can go external if and when the need arises. And then for most workplaces of probably more than about 50 people, you would be wanting to offer an EAP. That's called an Employee Assistance Program. That's a confidential counselling service. It's paid by the employer to support employees within the workplace and if they're dealing with a workplace issue, but actually also broader than that. So it usually can be used for anything. So that's a lot. All reasonable steps is a lot of things that the court are requiring an employer to do. Now, what we've done is we try to make it easy for employers. There's so much complexity in that. So if you have found this audio guide useful, we also have an e-booklet that you can download with all of those requirements. And in that e-booklet, we have links to various parts of our website where you can download some of the stuff that would be useful. So we have tried to make this process easy. We have written, I mentioned I'm a lawyer, we've written harassment, discrimination and bullying templates, a complaint management template that you can purchase. We have created posters that you can download from our website. We have a series of e-modules so that if you're part of a workforce that's quite difficult logistically to bring people together, then they don't have to. They can learn the content through e-modules. But we also have incredibly engaging content if you want to do in-person training. In addition to that, we've created the comms package. So we've created a series of emails and toolbox topics that you get complimentary anytime you purchase our e-modules or any of our in-person training. So if you'd like to know more about how to ensure that you are compliant in this space, but also that you are providing the very best support for your employees, then contact us at Equal Opportunity Training.